Hello, everyone. Welcome to a new year of the Global Lawyer, the podcast that started back in 2024, a very special year when the São Paulo Lawyers Institute celebrated its 150th anniversary. And here we are now, opening our first interview of 2026. Time really flies. And for those who are new here, I'm Marina, your host. Starting a year with a conversation on trusts, estate planning, and cross-border structures feels particularly timely. These are areas of the law that require distance from immediacy. They ask us to think beyond the present, to deal with continuity, structure, and responsibility in environments that are often uncertain and fragmented. In that sense, this topic offers a useful lens for reflecting on how Brazilian lawyers can better prepare themselves and their clients for an increasingly complex global reality. In times when institutional references feel less stable, conversations like this remind us that law is also built through technique, consistency, and long-term thinking. Over the past year, we have explored how Brazilian legal practice crosses borders, adapts, and reinvents itself. And as we step into 2026, that challenge only becomes more sophisticated, especially in areas where civil law tradition meets common law tools, private autonomy, and international planning. So it's a real pleasure to begin this new cycle with someone who has built one of the most consistent and technically refined legal careers in Brazil. Today, I'm joined by Roberta Corvo, a lawyer specializing in family law, cross-border estate planning, and trust structures, an area that invites us to rethink not only legal technique, but also legal assumptions. I'm really looking forward to this conversation, not because it offers easy answers, not that, but because it helps us understand where Brazilian lawyering may find structure, strategy, and coherence in 2026, and how we can move forward with clarity and professional responsibility. Roberta, welcome. It's a real pleasure to have you here.
Thank you, Marina. It's a pleasure to be here with you and to talk about something that I care about, and I work with it for more than 20 years. So it's something that it gives me pleasure to talk about and to share with you and all your invitees and everybody. So I hope to give you and all the ones that are listening to us my experience to share with you and
that's
let's see
fantastic.
how it goes.
Yes. And now, and before becoming, I would like to start from the very beginning. I would like to ask you that before becoming one of the leading Brazilian voices in trusts and cross-border estate planning, which is a really specific area, I'd like to hear from the woman behind the lawyer as we begin now. So what drew you to the law in the first place? Tell us, was there a moment early in your career, in your training, or even before law school, when you realized that dealing with families' most sensitive decisions would become central to your professional path? I mean, specializing in family law and estate planning is something that is common. But becoming an expert in trusts and fiduciary arrangements within a purely civil law framework like Brazil's is highly unusual, and it is quite a challenge. So was there a defining moment or an intellectual curiosity that prompted you to pivot and delve into this very common law structure early in your career?
It was not early. Well, first of all, what drew me to law was a mistake. It,
No.
it was not a destiny or a dream. I wanted to be a history teacher for high school. That was my dream. But then
No.
people told me that if I would go to law school, I could teach history. So I said, okay, so let's go. And it's not so for everybody who wants to be a history teacher, it's not true. So, but the thing is, I start to work very early in the law school, during law school in the first year, because my parents have a law firm. It's the law firm where I work today. So I start to work very soon in the first year. And my first field of law was corporate law. My father is a corporate lawyer, corporate slash tax lawyer. And the law firm has always worked with family business. So, as 90% of the business in Brazil and in the world, actually, it's not a Brazilian thing. So I dealt with family business for all my corporate career, let's say, and somehow we were much more to the shareholders side of the interest of what we were doing, that for the corporate self, like, I mean, for the business, I wasn't directly talk to the directors, but always the view of the owner. We were always trying to solve the interests of the owner. So it was a kind of a very natural path that I would start to be interested in what would happen in their succession as businessmen. Since we were there, and for sure, M&A, corporate restructuring and everything. But at the end, we are always dealing with a father who had children and who would be assuming his place at the end, and etc. So since we were always in this situation, dealing with corporate law, I start to deal with succession in companies, like in the families, and but in the sense of how the company would survive the founder.
Okay.
So this is how and then I saw the first limitations with Brazilian law, and I think this is. And at the same time, I was going to the US because I went to do my master.
Yes, tell us
So
about that. This is really
yeah,
interesting.
because since the law firm is used to be very small, so I was working as a lawyer actually since the second year of the law schools, dealing with M&A and corporate, like as I was a 5 years lawyer already, but. So I start to deal with important things and understand the limitations of Brazilian law in succession for companies, like the succession of the founder of the company. So I was very close to it. And Brazilian tools for succession are very limited. We will go further in this podcast, but and then it started to irritate me deeply because the real will of the founder, the person who built the whole thing, could never, be followed, because the manner that succession law in Brazil works is all about forced heirship. And I hate it. I hate forced heirship. I want to declare that. Because I think it's one of the biggest problems in our economic structure. Since you guarantee that half of the wealth produced by someone has to be to a determined person, a certain situation, and it, well, there is no flexibility on that. And the civil code of 2002, that I used to say the new code, because I am from that time. So the civil code make it worse because you could, after that, further to the forced heirship, you were not more allowed to made encumbrances. You couldn't, put anything on. So it had to be free and destinated to someone specific. So that's, well,
really
trying to sum up. I went to the US, and I've heard about at the time about trusts. I already liked the idea of how trust works, and then I said, okay, let's see how it goes in the place where they know how to deal with it, because until that moment, trusts in Brazil were known only as structures to hide money, normally from politicians, and related to criminal law. So it was something that was very connected to hiding money from that was received from crime in Brazil. That was trust all about. So that was my
it's so interesting. I didn't know that about your passion on history, and this is interesting. It's not to say that it is not you don't apply. You can say that you even this in the historic tech of trusts throughout time, from the 70s, 80s, and today. I think that is an evolution, a historic evolution that you can take advantage of, and thank God you went to law school, because I think in terms not to I have a great respect for history. My mother was a history teacher, so yes, but I think that the good impact and the good influence of you as a lawyer can spread good things throughout society and throughout the families in a much more impactful way. So I love your story. And speaking of curiosity, and because you went to the United States to study these different structures that we didn't have here, and we don't have here in Brazil. When you are sitting down with a client who's never heard of a trust, for instance, how do you make something so foreign feel understandable? I'm trying to dig into that. What are the main features of a trust? And here I'll have to ask you to give our audience a bit of a summarized explanation of this type of structure, and why are trusts not recognized under Brazilian law? I wouldn't say recognized, because in terms of taxation, we have the offshore laws, we have offshore act, but we don't have the institute, the trust itself, as a tool here in Brazil, because Brazilian law again relies heavily on forced heirship and the legitima, and legal concepts like usufruct and fiduciary substitution, and we have the fideicomisso for asset protection and transmission. So what are the main features of a trust to start with?
Yeah, I think the first thing that we make a lot of confusion here, and it's important to understand it, as the trust is an agreement, is a contract. Trust is not a legal entity. Trust is not an institution, let's say. Trust is a contract where you have mainly three big figures. The settlor, who is the owner, the original owner of the patrimony, the wealth, the assets, and he intends to destinate this patrimony in a certain way. And then we will go further on that after. But so the settlor, he agrees with a trustee, and that's a person. The trustee is the person who can be an entity, can be like a legal entity, or it can be a person, like an individual. There is no rule for that. Normally, we have legal entities to be a trustee, more for, because they are professionals, but a trustee can be anyone, a person, an individual, a legal entity, it doesn't matter. So, and this agreement, this contract between the settlor and the trustee gives all the instructions for the benefit of someone else, the beneficial. However, what is the main, what is let's say the magic? The magic, and that we don't have here and we can talk about it later, but we don't have anything similar to it here, is that the settlor, he really transfers the assets. I always say the settlor becomes poorer. He has no more this asset. So if I create a trust, I sign a trust deed, the trust settlement, and I transfer to forget about tax at this point, okay? But I transfer to the trustee this asset. It can be cash, it can be a real estate, it can be shares of a company, it doesn't matter. You can transfer whatever you have. The trustee, this person, either a legal entity or an individual, this person becomes the owner of the property, a real owner, a full owner, like we say. So the thing is, and then I will not get into very academic discussions, because if someone likes to discuss or to study trust, then you can go very further from here, because the nature of this transfer, the nature of ownership of the trustee and of the beneficiary can have multiple discussions. And why is that? Because and also consequences. But mainly the idea is that I will not get into the academic discussions, because we could stay here for like
forever,
10 years.
Yes,
but that's the idea. The ownership goes to the trustee. For this purpose of the podcast, the ownership is encumbered. Like there is a lion. Let's use this parallel. There is a lion to this ownership because the trustee owns these assets, but he has to deal with these assets as instructed in the trust deed. So it's not completely free. The trust property is allocated. It's aggregate from his personal property. So if I'm a trustee, your trustee, my house, my car, my bank account is in one place, and the assets I received from Marina as a settlor is in another place.
Okay, so
but I have these assets.
Yes, and this is, I think this is the most intriguing question for us here in Brazil in our civil law system, because from what I understood, there is the legal property is transferred to the trustee, and the beneficial the legal ownership is transferred to the trustee, and the beneficial ownership is going to be destined to the beneficiary. But it's it's as if we would split the ownership of the settlor. I don't know if, because for us here in our civil law system, for our civil law, as civil law lawyers trained in the civil law, it is difficult for us to separate the ownership into what the trustee has powers and control to do, and what is going to be enjoyed later on by the beneficiaries.
Well, I think, and that answers your question before about why in Brazil it's so hard to let's say to receive that, to have a trust structure. Let's have in mind that under civil law, we are very strict, and it's very clear since we are in law school that you have personal rights and real rights. Personal rights are, we call obligations, right? Obrigações, direito das obrigações. So personal rights are related to a person. Like if I have an agreement with you, Marina, either you have to pay me something, either you have to do something, and if you don't pay or you don't do, you owe me indemnification. Or I don't know, if you cause me a damage, it's not a contractual obligation, but you cause me a damage, you have to indemnify me. So, but it's Marina's property. It's something I have with Marina. It's person. So why we call, like in English, we say personal rights. And the real rights that we call here direitos reais are not related to a person, to Marina. When I have ownership over something, it's erga omnes. Anyone who invades or who I don't know how to say, like eviction. Well, eviction, I think it's so I can protect my right, my real right against anyone.
Yes, the eviction. This is a false friend. It's very interesting what you said. It's when you have a title, when the title does not belong to the person who says to be the owner, who declares to be.
Yeah,
direito da evicção. So to be ensured that title is legitimate, that title is
yes, and then once I have such title, I have the ownership, I can fight against anyone. That's the big, why I'm just going back on time, because maybe that's easier to understand why trust is not easy to accept it from this perspective, because from the common law perspective, this separation of personal rights and real rights are not that aligned. And when in Brazil, when you have like full ownership, can be, let's say, shared or can be divided in three big characteristics. It's usus, it's the right to use the thing. Fruits, it's the right to have its fruits, so that the asset raises. And what we can, it's a strong word in Latin, but it's abusus, is the right to dispose, the right to alienate or destroy. So when you have the ownership of something, you can use it, you can have its fruits, and you can alienate or destroy it. These are for us in civil law.
So use, enjoy, and dispose of.
Yeah. So this is full ownership. I can have bare ownership, nua propriedade. I can have bare ownership and give to Marina the usufruct, the right to have its fruits. Okay, in Brazil, in civil law, it's absolutely normal. What we don't have here is the idea that someone has the full ownership of certain property and another person could have also the full ownership of, like, the right to do it. It's not a division as
okay. I understood. I understand.
The idea either we can hold as co-owners. Co-owners we have, but then we have half of an entire property.
Yes, you have shares of the entire property.
Yes,
this is not about that. This is different.
It's not about that. So the trustee, he can use in certain limited to the trust deed, the right to use the fruit, to have the fruits, and to dispose. He has whole. And again, not going to academic things, but what the beneficiary has at this point when the trustee is in control of the trust property, he has a personal right against the trustee.
I see. Okay, so
if the trustee, because it's a contract, if the trustee does not follow what is in the trust deed, the beneficiary can say, listen, you have the obligation to do like this, or either to distribute, either to take care. So it's not that the beneficiary at the point where the trust property is under the trustee control, he has no what we call a real right. He cannot say to any, and this is very important to the next points we are going to discuss, the beneficiary cannot say to anybody or to fight for the right of having this property.
Yes, he cannot enforce it.
Exactly. Because he has no real right, direitos reais, over such property. He has a personal rights against the trustee.
Yes, and maybe that's why Brazilians, or our clients, I mean, are so reluctant, or sometimes reluctant in about setting up a trust, because they say, okay, I'm going to dispose of my property, I'm going to transfer it to the trustee, to the benefit of the beneficiary, but the beneficiary won't be able to use it. Okay, so I'm not the owner anymore, and the beneficiary is not the owner yet. So I'm not sure I'm going to do that. So I think your role in this at this point is crucial in convincing your client that, yes, okay, this is safe. You can do that. And I love how you broke that down, Roberta. It really shows the clash between Brazil's rigid heirship rules, the forced heirship, and the flexibility of trust. You see, I was doing a bit of a research before our conversation, and we see that there are revocable trusts, irrevocable trusts, many different types. That there are. It's a really flexible tool, and once we understand it, we should adopt it with good advice, with proper and professional assistance, because it gives us leeway to do many things with what we have built in life, right? So the trusts, they are designed to asset protection, others more focused on asset planning and succession. And depending on the jurisdiction, it may considerably change the legal strategy. Like I've heard, I don't know if that's correct, but in the USA, if I'm not mistaken, only the states of Nevada, Wyoming, Alaska, Delaware, and Utah, South Dakota. Right, South Dakota. They have asset protection trusts, which means that the very settlor is allowed to also be the beneficiary, and many other features. So it is interesting to see how jurisdictions, how the rules vary throughout the many offshore jurisdictions. Offshore may be United States and the Cook Islands, the Bahamas, the BVI. So now, as you just said, now theory aside, looking at practice, Roberta, since you are the expert here, do you remember the first time you had to advise on a trust that would be holding assets both abroad and in Brazil, to a client in Brazil? Again, in a cross-border scenario involving a Brazilian citizen, a Brazilian client with significant assets, both here in Brazil and abroad. What would you say that are the three most critical circumstances or the trigger points, be they tax, succession, or family governance related, that lead you to conclude, yes, a trust arrangement is the necessary solution over purely domestic Brazilian instrument in this case? So in other words, what are the benefits of using trusts for succession planning by Brazilians?
Well, going back to the first
yes,
question, if I remember the first time I tried or talked with a client, a Brazilian client, about having a trust, yes, I do. He has gone already, but he was for sure one of my favorite clients, like someone who taught me a lot and who trusts me a lot, because I was very young. and he was already very experienced, and he trusts a lot. In a moment when we are young, it's very hard, although you can have all the knowledge or everything, but you don't have the experience. So, but it was great. I do remember, and I think his case is a very good one to tell, because it's the very good reason, for instance, to have trust. He used to have a child that he wouldn't trust. Not about it wasn't a problem of he was a good child, but
Okay, it was not
he was a child that he was pretty sure that there was a risk of losing the entire property.
okay.
It was almost like our prodigal. We have so
spendthrift.
it was a problem in this sense. It wasn't a problem of character in the sense of a bad person, but a person who wasn't able to manage it. So he knew his child would have a lot of money to live his entire life very well, because he was a very rich, very wealthy man. So his child would be fine. But he was worried about his grandchildren, because in his mind, the wealth that he construed during his life wouldn't reach the grandchildren or the grandchildren, and which was a lot of money. Okay. So, but he was really like, I don't trust him as a manager of wealth.
Okay.
And you don't have anything in Brazilian law that you can first jump a generation like that.
Yes.
What you have, for instance, let me be very simple. For sure, you can dispose of half of your property for instance, to your grandchildren, but sometimes you don't have the grandchildren don't exist.
They are not living.
Yes, or you don't want just to have the grandchildren's right to receive, but you want perpetuity. Yes. You want this because it's a lot of money, it's a lot of it's a huge property. You want this to as long as possible, and give a great life to a lot of generations, because it was a good property. So you don't have this in Brazil. Mainly, we do have similar tools that could, each tools, and that's a point that we are never a trust lawyer in Brazil. There is no such a thing. Okay. We are a succession planning lawyer, or a estate planning lawyer, or a wealth planning lawyer. Okay. And why I say that? Because it's very important that trust is, let's say, the last thing you should look at. It's not the first one. For sure, sometimes it's so clear that it's the only one that you already, But the thing is, you do have a lot of tools under Brazilian law, a lot of tools, but they have limitations. So I would say the first huge limitations is that we are not allowed, and it's void if you do it in a will, for instance. You are not allowed to say when and if someone is going to be a beneficiary.
You can't put a condition on that.
You do have a legacy with burden, or a donation with burden. We do have a doação onerosa ou legado. We do have. But the thing is, if the person does not comply with the burden, the person loses this right to have the property, but then the property goes to someone else that is already stated. So it doesn't it doesn't goes for next generations or something
You
like that.
can't preserve it to last, preserve it for the next
Yes.
generations. And
This is, I think, is the big limitation we have.
okay.
We we can only we as the one who were able to build something, we can only say where this property we've built goes only in a very strict limited of limit.
Yes, it's a narrow
Time.
window. It's a very narrow window of time.
Very narrow, yes. And I think this is unfair
Yeah.
because it's, I think people should have the right to say,
choose.
I love my clients that says, I don't care. If my children lose everything, I don't care. I want them to be free and they can marry whoever they want. I love this kind of clients, really, because I think they are, free. And I think that's great. But it's not everybody who is like that.
Yes.
And
yes.
so the main point is this narrow disposition we have in Brazil, I would say. That's where the trust should get into.
Yes, and this example, this is super telling because it's clear why trust can be a game changer in certain situations when it comes to a specific family structure and a family wealth, and there's something more. Once you've set it up, so once you've set the trust up, a question remains. What happens when Brazilian courts get involved? So this is another problem. So how do you deal with the risk that they might not even recognize the trust when local assets that are located in Brazil are in place? So a key concern for Brazilian lawyers is the recognition and enforcement of foreign judgments and structures. So if a foreign trustee is compelled to repatriate or dispose of an asset or turn it over, or if a beneficiary attempts to enforce, just like you said before, enforce their rights, how does a lawyer mitigate the risk that a Brazilian court will refuse to recognize the trust's legal existence for property located within the national territory here in Brazil? And are there specific types of assets, let's say real estate versus financial asset stocks, that present greater jurisdictional challenges? In a way, would that be a limitation? And if not, what are the limitations on using trust in Brazil as a tool for succession planning? I don't know if you got everything. Sorry, so
Yeah.
many things
No,
I would like to know.
I got it. And actually, this is one of the main worries, right? Because I always make a joke with my young lawyers in the law firm. I say, and to the clients, I say, the greatest thing about my field of law is that when my client would be able to, have a claim against me and appoint a mistake, he's already dead. So this is and that's something
This is interesting.
that makes a field of law full of bad lawyers.
Because they don't
That's a very
care.
point.
Okay, if that's a problem for the future, so I don't have to.
Yes, that's something
Oh,
very
so you
important
are
to mention. Like
okay.
reckless, let's say reckless,
Uh-huh.
not bad lawyers, but reckless lawyers.
Okay.
Since
The consequences
the person who is hiring you, the person who pays you, is not going to see if what you've done
is
is
correct.
executable. Like, not
Oh my God.
executable. It's effective, right?
Is effective.
It's enforced, able to be. So it's a very a dangerous thing, and you have to
Wow.
be very. And I'm always joking about with the client. I said, hey, listen, I can be reckless with you. You're not going to be here, but it's a joke for sure. So this is a important point. But anyway. One of the things that in this discussion, I think we tend to look to the wrong side is that it's not very important for succession law and the enforcement of a trust if the trust is recognized in Brazil. If a trust deed exists in Brazil, this is not
Okay.
this is my opinion. Okay.
Okay.
The most important thing for me to make sure that the contract you've done with a trustee is enforceable is that the transference of the assets are well done. You have to be careful. Why I say that? Because once the transfer of the asset is done according to Brazilian law, is done in a right way and in respect with the Brazilian law, nobody can seize it. Nobody can go and take it back. So you don't have to worry. Like I said in the beginning, the trustee is the owner. It doesn't matter. The beneficiary has no way, or any other person, let's say another heir, like if you have a heir that could be not happy with the establishment of the trust or anything, once the transference of the asset is done properly, the let's say the Brazilian jurisdiction is over. The asset is not under jurisdiction of Brazilian, because the owner of the asset is a trustee, is a foreign person. The trust deed is according to the law that you chose to have a trust. So if Brazil recognizes a trust or not is not a problem. And if you want to do something, you have to go there.
Yeah.
And this is why sometimes I think the discussion goes to a wrong path, because people, no, but the trust is not recognized. It doesn't matter. If I send, so, and then you have a very important point, and we are always coming back to this point, is the forced heirship. We cannot have a donation that goes further to 50% of our assets in the time of the donation. So to set up a trust, to set up a trust property, and therefore to transfer such property, you have to respect such limitation the moment you make the transfers. Otherwise, what you add, that it goes further, that is, you could have this someone to claim that is not a legitimate, a correct donation. However, a few points. There is a discussion about that in Brazil, but in the moment I make the donation to the trustee, I am alive, and I have people around me that they have potential rights, expectation of rights.
Yes, and this is something that is important for the audience to understand.
Yes.
Because you don't speak of herança de pessoa viva. So you don't speak of inherited property that belongs to someone who is still alive.
He's alive, exactly. So if someone will challenge my transference to the trustee, there are chances, there are discussions. Currently, we do have few discussions about whether this heir, because it's let's say a problem to the forced heirship, if to not lose the right in the future to whatever. There is this discussion in legal court, in Brazilian courts, okay? But it's a very, very weak
argument.
How can I say that? I don't know how to address it, but it's not strong argument to challenge my donation,
because
to say that I'm alive, the assets are mine, and at this point, although the civil law says that I cannot donate more than half, I'm still alive, and you are not my heir.
You are not my heir.
There is no heir. You can predeceive me. You can go before me. So don't come and
go first.
Yes.
God forbid, but
yeah. But so this is something that is tricky, but it's important. I recommend normally to not go too further. So respect
Okay, the
half,
percentage, the
the
half. Okay.
legitima,
Uh-huh.
because this you are under Brazilian law, so
So
you
you
should,
avoid, it's
yeah,
better to be on the safe side. I see.
yeah. And since you are really transferring the property, like I said in the beginning, the settler, he became poorer. He has no, these assets are not part of his property anymore. So there is a new number of what is half and what is the legitimate.
Okay.
In the
So you
second,
have to
but this is for
work.
any donation, Marina. If I
Yeah,
forget about trust, if I
I
give
see.
half of what I have today to you, tomorrow, the legitimate of my children is
Will be
already
shrink.
25.
Yes, it's going to be reduced. All right.
Okay, so
So
this
you
is
are,
something just to have in mind. So it's tricky, but this is, and this just as you asked, but why we don't have Brazilian tools that do that? No. Why? You can, for instance, transfer part of your property to a legal entity, like capitalize, for instance. But then I'm not transferring out of my property. Why? Because I'm just changing the nature of my property. I used to have, for instance, money, and now I have shares of a company.
shares of stock.
But
Yes,
I'm
shares
not
of
poorer. I don't have less money. I just
less
not.
assets. Yeah.
Yes. So I just changed the name, but I still have this patrimony.
It's
This,
still yours. It's still yours.
yes. And
Yes.
so I think I covered
Yes,
the
you covered everything. I'm just processing here because you have raised a few important points, and now I'm thinking about jurisdiction, and because when advising on the jurisdiction of, uh, assuming that you conclude that it is interesting for a person to establish a trust for your client. Uh, so your client is going to be the settlor. So you are, at this point, you are making a critical strategic choice. How do you assess, how do you evaluate the trade-off between a jurisdiction known for, let's say, robust asset protection, like the BVI, the Cayman Islands, or Cook Islands, or you name it, versus a jurisdiction with a more predictable and recognized legal system, like the UK or the United States, or any state within the United States. So specifically, how do you ensure, I think this is a great problem, how do you ensure the fiduciary duties of the foreign trustee are indeed aligned with the Brazilian client's long-term family vision, even though those duties are legally defined under a foreign common law?
well, the first thing you have to look at, each case is a case, each client is a client, and each family is a family for sure. But I don't think we are among lawyers, so I don't think this is a new statement. But the thing, so there is no formula that's important to be said. The the residence of the beneficiaries matters a lot, because I'll give you a simple example, and a lot of people know that. For instance, if you have a child that is living in the US, you have a very, very strong tax on heirship. It's not a problem when a foreign father, mother dies and the person residing there receives, because at this point there is no tax in the US. But the problem is that the moment the child living in the US receives the assets, and depending on the amount of such as, like the value of such assets, this child has nothing else to do it, because to establish herself a trust will not escape from the tax,
From the
gift
taxation.
Gift tax or hair tax. So,
which is 40%, if I'm not mistaken, right?
40% is
40%.
the federal.
Okay,
Yes. Depending on the state where you live,
you're right.
you have the state also gift tax.
Yeah, sure.
And so you could say, okay, but my child lives in the US, and I know if I die and she receives everything, there is no tax. Yeah, that's true. But once the assets are in her hands, and if it's in an amount bigger than the limitations you have to transfer to trusts without tax, then she cannot do anything else. So your grandchildren will have to pay this tax. Okay. So, for instance, I'm giving this example because it's a very well-known example. So if you have this kind of situation, it is important to have a trust set up in the US. Even though while I am alive, I don't want to have a trust taxed in the US because I'm still alive. So there are tax issues here, but I would rather go to the US because once I die, tax issues in the US, if you have a foreign trust, are very bad. So this is, for instance, one of the things we have to pay attention, where the beneficiaries live. But let's suppose there are the second thing, costs. For sure, you have things that are very complex and structures that are very complex, and it is interesting if your client has such an amount of assets that make sense, but sometimes it's something simpler. So you can do something simpler that is fine and reach your goal as well. So this is another thing. And I think the most important one, trusts, they can deal with distribution of the principal. It's like the asset I add to the trust property. And they can deal with distribution of income. So let's suppose I put $1 million in a trust. Okay, I transfer to the trustee $1 million. I can say, for instance, that I don't want this principal to be touched in any way. But all the income that derives from this 1 million should be, for instance, distributed for my children during their lifetime. This is a very common, for instance. So I'm preserving the principal and distributing the income. This is one of the things you can do it. You have a long-term relationship with the trustee in this case. It's a lifetime of your children. So you have to do something very strong and very safe and very well done. You need, by the way, you need always a partner in a place where you are going to set up a trust. Please.
Yes.
I see lawyers in Brazil
trying to do by themselves. Oh.
No, don't do it.
You don't do that.
We are not that people. We are just Brazilians. Don't come with these ideas. So you have always to have a partner, a local partner, but you have to have a very strong structure because this is going to be a long-term relationship. On the other hand, you can have a trust that, for instance, to prevent, this is very common as well. I want to prevent probate. I don't want to have a probate because a probate is a nightmare. It's full of conflicts. It's sometimes expensive and it takes time and whatever. I die, the person receives, and that's it. It's a very common trust. And this is something that really works. Then, since it's a one deal, it's just when the person dies, you transfer the assets. So you can have a very simple place to hold these assets, a very simple structure. So you see, there are variations that matters a lot.
Yes. So I like how you frame that because it's not just about the duties and the fiduciary duty, but it's about aligning with the family's long-term vision?
Yeah.
For
And
what's the purpose?
yes, and also you said about how few, aligned with the family purpose and everything. When you set up a trust, I said we have these three main figures, like the settlor, it can be called grantor as well. It depends on the
And
jurisdiction
the
and the
place.
place and the whole. You have the trustee itself and the beneficiaries. But it's very important to know that you have protectors. The fixture,
Yes.
the
Yes,
the
that's
the the
that's
protect.
optional, but it is important to mention.
It's important, and mainly because you said in the beginning, Brazilians are not individuals that rely on trust because we are like, well, we behave as we are, right? So probably we are not that trustful as well. So yeah, it's a matter of culture. I don't know. The thing
Yeah.
is, we are like, okay, how can I assure this person is not going to take my assets away or whatever? So the fiduciary role is a very difficult thing to be understood. But the thing is, the protector is a hole in the trust structure that makes it closer, the trustee closer to the settlor and even the beneficiaries. The protector normally is someone who knows the settlor, who knows the wills of the settlor, who understands how the settlor used to work, to think. So I would say it's important when you have a protector, either a protector or a committee. Sometimes you put more than one, like a committee of protectors. People who really know the client, the settler, because they know how they reason, they think,
Yes,
they
they know
want.
yes, what's behind the decisions, what
Yes.
lies, they can do, they can see what you can't.
Yes. And then when you were dead, like when the settler dies, and then you have just the trustee itself, you have this protector to give you the mind of the
Yes,
dead person. Let's say this ghost, a ghost
yes,
writer.
yes.
So you have the protector in certain jurisdictions. You have also what it's called distribution advisor. It's also to distribute. He first has to approve, and also, and that's important. Like the investment advisor, the financial advisor. So because the main role also from the trustee is to manage such assets in a proper way. So sometimes you don't want the trustee itself to do it, but you want, I don't know, a bank or a wealth.
Yes, someone who understands. Yes, who is in the knowledge, in the know
Yes.
depending
So
on
you
the.
can direct that in the trust deed. And there is also the famous letter of wishes.
Yes, I was going to mention that as well.
The letter of wishes, they are not exactly an enforceable document, but they have this whole of translating the wishes of the settler, what he would like to how he would think in certain situations.
Okay.
And since you have something, and this is the most difficult thing to Brazilian law, Brazilian courts, and our IRS
IRS.
understand, is something about that's called discretionary power. It's much more important than being revocable or irrevocable.
Or revocable. Okay.
If you have a discretionary trust, it means that the trustee has the power to do whatever. So for sure, always in respect to the trusted, but he has full power to decide. And in these cases, it's not true that, for instance, if me and my brother, we are just the two beneficiaries, then we have half of the trust property, for instance. That's not true. because I can be in a situation, I don't know, for instance, I'm using drugs and the trust deed set up that I cannot receive anything if I receive drugs, then my brother will be the one to receive all or whatever. I'm just giving a stupid example, but it's very common. So
Yes,
it's not
it
true
happens.
that for instance, what the law now in Brazil says that I should pay tax over 50% of the trust property. It's not true because of discretionary powers of the trustee, but whatever. So when I want to, the letter of wishes, mainly in the discretionary trust, they are a very strong, a very powerful tool to give directions to the trustee. He's not bound to it. He's not obliged to respect it.
I see.
As a fiduciary entity, let's say, he normally complies with. Yeah, you cannot enforce him, but he normally does it.
Yeah.
And lastly, but not least, and maybe this is the safest one, is normally you put the assets inside a legal entity.
Yes.
And then you donate, you transfer the shares.
Yes.
And why is that? Because then you can put in the legal entity, in an offshore company, whatever you decide to, you put in the company the structure that you understand works better. So for instance, who is going to elect the directors of the legal entity? What are when the directors of the legal entity should ask the shareholder, who is the trustee, about something, when they should distribute dividends, because they're going to distribute dividends to the trustee, and then the trustee is going to distribute to the beneficiaries. So the legal entity between the trustee and the assets themselves, it's the main thing, and the trustee likes it because it gives protection.
So it's generally an
also.
LLC, right? A limited liability company.
It doesn't.
It doesn't matter. Okay.
It's not. It's not. It can be a Brazilian company.
Okay.
It's not a problem.
Okay. So the Brazilian
normally it's related to tax issues. You combine, and then it's not. And sometimes, for instance, a LLC, for instance, can be viewed as a transparent company.
Okay.
And then you can be taxed on the assets themselves.
You lose everything.
So it's not very easy. But the thing is, there are lots of components to decide. Normally, tax issues are very into it. So this is also why someone who deals in this area has to understand tax law. You don't have to be a tax lawyer,
but you have to understand.
You have to acknowledge it. You're not going to be far away from tax. No, never.
Yeah. Okay. Yeah. They are all intertwined, and you cannot ignore that. And okay, so we are almost reaching our time. And Roberta, tell me, as we start the year and looking ahead, your career is a testament to the value of deep specialization in international law, right? Now, if you were talking to a young Brazilian lawyer today who wants to do this kind of work, who is determined to build a career focused on global, strategic, and wealth and property choices, the kind of work that involves constantly bridging the divide between civil law and common law traditions, what would you say to him, to her, or to them? What would you tell them as a piece of advice?
I think the first thing I would say is that be prepared during Christmas Eve, that nobody will know what you do. Because my friends think I am a tax lawyer. Other friends think I am a family lawyer. My family thinks I am a corporate lawyer. My husband,
This is
I don't
so
know what he
interesting.
thinks. So nobody knows what lawyer I am. And I sometimes I feel like I told you before, I feel alone because I'm not in the tax group, I'm not in the corporate group, I'm not in the family group, I'm not in the either, I'm not even in the succession group because it's a very specific way of dealing with succession law. So
Very
be
interesting.
prepared to be a
Multitask.
multitask, like tasks. You have to know, it's not all, but a lot of these fields of law, like I mentioned. You have to know family law because there are implications on divorce, on marriages, on things that I'm marrying now. What kind of words I should have because of my children from my previous wedding or whatever, or I want to leave my assets, but I don't want the I forgot how to say cônjuge.
The stepdaughter, the spouse, the
The
spouse's
spouse,
daughter,
yeah, thank you.
children.
I don't want the spouse of my children to have access to it. And so you need to understand family law. You need for sure to understand succession law, Brazilian succession law, because I hear a lot of bad answers because person does not know anything about succession law in Brazil, and then they want to give an opinion on that, and that's terrible. So you need to be a Brazilian lawyer because you need to understand your limitations on what you can do and what you cannot do. You need to know tax. Unfortunately, like I would say that the only thing that is good is actually it's direct tax and mostly individual tax, sometimes corporate tax, but mostly individual tax. So gift tax, for sure, gift
and succession and
inheritance tax, and income tax. This you have to understand pretty well to move forward. And corporate law, maybe my beginning corporate law gives me a good place to be because that's something that normally like family lawyers don't know very deeply.
Because you have to think about the whole structure.
Yes.
Who are the parties or the actors?
Yeah.
How to balance out.
Yeah. So it's too many things, and there is something also that I have no problem in doing as well, is to work together with colleagues.
That's fantastic.
Actually, I think it's the nicest thing to do. So if I have a very complex, let's say, tax problem, I rather go to a very good tax lawyer that I know, that I trust, and put she in my team and make sure that, I'm not going into a place that I'm not that technically good.
This is important because you are thinking about your client. This is a
lawyer. The same with family law. I work a lot with family lawyers because sometimes it's a very specific issue that I'm not, technically able to do it. And as I said before, you have to have local partners.
This is definitely.
We are there for Brazilian side of the issue, not to
overstep
so that's important. So that's it. You're going to be a strange lawyer
that
nobody knows what does.
yes, but it's great. Oh, Roberta, thank you for such a thoughtful and generous sharing of your large experience. You told us that you started the first year of law school. This is a privilege because your family office, so your family law firm. This is an opportunity that not everybody has. So it provided you with experience, and it allowed you to develop your expertise, so to grow your expertise. So your work shows how technical rigor, comparative insight, and sensitivity to context, that's as you just explained, depending on the family, the wealth, and how they can coexist, especially in an area that asks lawyers to think beyond borders. Beyond borders, I mean beyond your field, your multifaceted field,
Yeah.
beyond immediate disputes, and often beyond a single legal tradition. So I think it's just admirable, and it is fantastic. Thank you so much.
Thank you for the invitation. It was great.
Oh, thank you. So, to everyone watching us, I hope this episode has offered not ready-made answers, but useful tools, and perhaps a, a different or a different way of looking at planning, responsibility, and legal time. In moments when institutions are questioned and certainties feel more uh, fragile, serious legal work often begins exactly there, with method, consistency, and the willingness to think long term. So I'd like to close with a thought by the German legal philosopher Rudolf von Jhering, who once wrote, "Law exists to be realized." In other words, law does not live in abstractions alone. It takes shape through practice, through structure, and through the choices lawyers make every day. And here we have today a wonderful example of a lawyer, a practicing lawyer who makes the difference for many families and many company owners as well, who is our dear Roberta Corvo. And thank you all for tuning in and for joining us on The Global Lawyer. I look forward to continuing this conversation throughout the whole year of 2026. See you in the next episode. Bye bye.
Bye bye.